decision. It makes it easier for the Kenyans to move on. And we want to say to all Kenyans that Kenya Kwanza government will not be just for the Kenya Kwanza supporters. It is a government for all the Kenyans. So do not feel left out as a Kenyan. Our doors are open. You belong here. We pray that there will be peace from now going forward. And don't feel as though you are not part of the incoming government. You are part of the Kenya Kwanza government. If you are Kenyan, we love you, we want you in, and we want to work together with everybody. We thank the judiciary led by the CJ for the great work they have done. They have done these proceedings in a very excellent, ethical, and professional manner. The lawyers have conducted themselves very well. And we know that the democracy space in Kenya is growing, and together as a nation, we can develop. Together as a nation, we can concentrate on the issues that are affecting mwananchi. So it will be bottom-up economy for everybody. It will be a new season for everyone, and we believe we will grow together. Asanteni, God bless you. We will have our council say a word. Gatia, thank you.
What will do?
Gatia advocate, say something.
Yes, habari yenu. Yes, the client, the president-elect, will be making a statement later. Mine is just to say it's been a very, very engaging period, and we are thankful. It has now ended. The time for court cases has ended. The time to assemble a new team has now started. We now move forward as one country and as one people. Asanteni sana.
So you will receive the statement from the president-elect, His Excellency Dr. William Samoei Ruto. Thank you.
Senator. Si rais. Vengo ndio huyo.
Teremsha mic kidogo.
Now substitute from
Well, are we all right?
yes, yes.
First and foremost, I want to thank our team of lawyers. As we know, we are a team of nearly 50 lawyers, and we have been working very hard for the last 14 days, this being the final day. Secondly, we want to thank our clients, the petitioner number 1, Raila Amolo Odinga, petitioner number 2, Martha Karua.
Hello everyone, congratulations on downloading Clean My Mac X. In this video, we're going to
team, including Senior Counsel Stephen Kalonzo Musyoka, for having their trust and confidence in this team of lawyers to prosecute their case in petition number 5, which has been consolidated with other petitions, and put their case before the Supreme Court. I want to say without a fear of contradiction that we do not agree with the decision of the Supreme Court. Like Al Gore, I will say we accept the decision, but we do not agree with it. And I'm saying this as a seasoned practitioner that courts sometimes make mistakes which have to be corrected over time. Courts make political decisions. As you know, in the United States of America, there has been a long-standing case that has been held as universal truth of jurisprudence involving women's rights, Roe versus Wade. It took them 50 years to overturn that case because of a Republican Congress and a Republican president and a Supreme Court that was basically appointed by Republicans. And therefore, I want to say, yes, in accordance with the law, we got to accept this decision as the law of the land. But I think it is a very ideological decision. I think that a lot of what was said in the judgment, and we'll have time when that judgment comes out to put out a critique. But all it means is that in our jurisprudence, the petitioners will always have a big burden to carry when you have an electoral commission which is not open and transparent. The best way for this court to have made a decision was with the servers to be fully opened and all the election materials be placed before the court, as would happen in a case where justice has to be rendered. As you know, and I am saying this again without fear of contradiction, we wanted a comprehensive audit of not only the technology that was applied by the Electoral Commission, but we wanted a proper audit. Although time was of the essence, but I think we had sufficient time to carry out a proper audit, including looking at the issue of the foreign intruders, the Venezuelans, which you'd notice the court avoided in making any comment about those intrusions and invasions of the system, the technology, the IT structure. That again, the court did not refer to, but probably in the judgment, the recent judgment that is coming on the 21st, they will say something about it. And therefore, I want to end by saying the rule of law should prevail. The court normally has the last word in making a statement as to what is the law of the land. But as citizens who are sovereign, we're entitled to disagree and disagree very vehemently. I think the court, in conducting the proceedings during the hearing, I think they were patient. They listened to us. It is only the outcome that we do not agree with. Finally, I think our clients, the two petitioners, Raila Amolo Odinga and Martha Karua, may be addressing another press conference, but we are happy to talk to you on this issue. No, I mean forgeries. When the DCI, the Director of Criminal Investigations, what do we put before the court? A lot of it was from an agency of government. I didn't see them talking about similar incidents in matters concerning the Independent Electoral and Boundaries Commission. That's why I was saying it was a little ideological. They were looking for things on which to destroy our case, but similarly not taking sufficient time to look at what happened on the other side. And that will be another story for another day.
Would you admit you might not have been well prepared for this case?
We were very well prepared. I think compared to 2017, we were a lot more well prepared.
What would be the 2 or 3 points of mistake that you say the court might have made mistake on that?
In 50% plus 1, I think they were ideological. We are using the baseline of total registered voters in the land as against those who turned out to vote. If you read any legal material on what should be a turnout, including the Black's Law Dictionary, turnout is normally based on the registered members in a country as against those who turn out to vote. So there are so many other examples we can take up. Yeah. The issues that the court formulated, but we're quite happy to live with it and talk about it another time. Philip, you would want to say something?
Just on the idea that we lost on all 8-9 points, we find it incredible that that could be the holding of the court. In more than several of those cases, we had overwhelming evidence. As my senior counsel, Mr. Orengo says, the servers were not opened. The involvement of the Venezuelans for a full month before, half a month before the elections and up to the 16th of August was not explained. No, it wasn't even offered. We perhaps are a little distressed on the over-reliance of a registrar's report that has no input from us. That report was completely silent on the failure to open the servers. The servers, repeat, the servers have all the answers. The exact role, we provided evidence that the Venezuelans were downloading documents, creating documents, and generating documents. None of that was touched. But as my colleague says, we hope they'll address all this in the final judgment. As somebody has said, it's incredible that we could lose on all points and they could win on all points. But as Senior has explained, it's probably the ideological aspect of this judgment.
Are you still confident on the 21st it will be a different ruling?
No. They have tied their hands. They can't get out of it. They have given their final decision. It's now a question of them finding the reasons for those findings and justifying them. It's not always easy, but I think they have some time to do it.
The other thing that I found a little bit disturbing is the presentation of the Form 34A by somebody I really respect as an advocate, Julie Soweto. It was described as hot hair, but you could see when that evidence was being adduced before the court, how engaged even the justices were. So I found it rather odd for them to describe it as hot air. I think that's why I'm saying this is ideological, because they would have said on the evidence presented, we find there was more weight as to the evidence which was adduced by the other side. But to say that it was hot air and it was a document coming from the Electoral Commission, I found it very, very disturbing.
If I may explain a little further on that point made by Julie Soweto in the petition, that gentleman, Camargo's name was not supposed to be on Form 34A. If at all he was involved in this election, he was involved on the technology side. So to find it anywhere near a Form 34A raised more questions than answers. There was silence. And of course, on the issue of the famous 34A that Julie was describing, it was found to have been signed by the agents of UDA and UDM on the 7th, which is before the elections. No mention was made of that. So many things, many questions, perhaps more questions than answers, but it is the decision of the court. They have to live with it just as we have. Is that all? Thank you.
Agenda, Professor Agenda, may want to say something. Okay.
Sawa.
Thank you.
Kuna mtu amemkanyaga yote hapa tu.
Live images coming through from Kenya. The Supreme Court confirms the RUTO election The judges unanimously voted to uphold
Well,
RUTO
those
win.
are live pictures from Sugoi and the supporters and residents of that area celebrating that ruling by the Supreme Court, where the Chief Justice Martha Koome-led bench has unanimously thrown out that petition by the Azimio la Umoja One Kenya coalition candidate Raila Odinga, arguing the declaration of William Ruto was null and void. Justice Koome says the court will issue a summary and then give the full judgment after 21 days. And we also did see some reactions from the legal representatives for the petitioners, that is Siaya Governor James Orengo, as well as Philip Murgor. They're speaking about some of the issues, saying they do thank the petitioners for the time, they accept the decision of the court, but do not agree with it. They're saying the court sometimes make mistakes, but of course they're looking forward to that full ruling to see their questions and arguments that are yet to be answered.
Yes, and we've also seen other reactions online by relevant persons, and one of them being Martha Karua, who's the presidential running mate for Azimio la Umoja One Kenya Coalition Party. And she has tweeted that the court has spoken. I respect but disagree with the findings. Same thing as what James Orengo and the rest of the Azimio team of lawyers has said. Aside from that, we've also seen a man who's been very vocal in regards to this, and that is Francis Atwoli, the Secretary General of KOTU. He has tweeted, during the KOTU Kenya Executive Board meeting on the 17th of August, we resolved that immediately after the Supreme Court judgment, we must thank and congratulate the victor. Consequently, we congratulate President William Ruto. We appeal to workers and Kenyans in general to remain peaceful. So that is KOTU Secretary General, that is Francis Atwoli. And right now we are expecting the president-elect to speak from his current residence, which he will soon be moving out of. And like Zainab had pointed out, the swearing in is expected to happen next week on Tuesday. Indeed. That's the 13th of September 2022. Yes, next week Tuesday is when we expect the swearing in. So in terms of just what is expected, we expect that the Interior CS is meant to gazette the day as a public holiday, so that we can make way for the swearing in.
And indeed, that is actually laid out in the Constitution, because you have the first Tuesday after 7 days of the pronouncement of the petition by the court. That's when that is set out, and in this case, then it would end up settling on the 13th of September. That's on the first Tuesday after the 7 days, which is of course next week on Tuesday, the 13th of September. Yeah. Let me just look a little bit deeper, Dana, into some of those issues as we continue to get those live pictures from the different parts of the country with regard to this. Yeah, this is actually Karatina. You can see better on the screen. Well, the 7-judge bench today made its determination. Like I said earlier on, it was based on the 9 key issues that were within the consolidated petitions, which sought similar reliefs. So there was the first question, whether the technology deployed by IBC had actually met the standards of integrity, verifiability, security, and transparency to guarantee accurate and verifiable results. Well, according to this ruling, upon considering all the pleadings, submissions, and the ICT scrutiny of the vote tallying and recounting report, which fully examined the IBC's election systems, they are saying they were not persuaded by the allegation that the technology deployed by IEBC had failed the standard of Article 86A of the Constitution on integrity, security, and transparency to guarantee accurate and verifiable results. They're saying, whereas the KIMS failed in 235 polling stations, more than 86,800 voters were granted rights to vote manually, and forms 32A were duly filled, and that in their view, the petitioners failed to produce evidence to the contrary. Dan, I'll give you the opportunity to look at the second matter, which was whether there was interference with uploading and transmission of Form 34A from polling stations to the IBC public portal.
All right, thanks for that, Zainab. And before I even just chime in, I would just like to The DP, like I said, the president-elect, now we are used to calling him the DP, but the president-elect is going to be addressing
Right.
the nation shortly. That's what you can see on your top left corner of the screen, as we see the different places in the country, parts of the country that are up in celebrations following the judgment delivered by the Supreme Court. And I just quickly want to get, as we just monitor the screens, quick comments from our guests in studio who are here from the previous session with Nur Abdulaziz and Nicholas Wambua. Wakili, what is your feeling about, what's your initial comment about this judgment?
Right.
I think that this is great for the country. This is exemplary work done by the Supreme Court. As we said earlier, here is a dead-end road for at least those who were hoping to succeed and did not succeed. That's a turn of the road. I mean, they've got to immediately agree with the Supreme Court. We have seen comments from senior counsel, trying to say we don't agree with the judgment, but the judgment is there. That is neither here nor there. The truth is that the Supreme Court has made a finding that William Ruto is the duly president-elect of the Republic of Kenya. Every language and every tongue must change and accept and move with the Supreme Court and recognize William Ruto as the president of, because there's really nothing else you want to bring up. There is really no other alternative. The Supreme Court has spoken, the people of Kenya spoke, and it has now been concluded that William Ruto will be president of the Republic of Kenya. I think fortunes and dynamics now change. All the promises made by the president-elect, people will start counting going forward. Has he done this? Has he been democratic? Has he done ABC? I think the Supreme Court ruling has given him that leap, the chance to make things differently. Because there's too much, mud which has been thrown towards that direction. But the Supreme Court seems actually to have exonerated him to some extent when it says that the petitioners did not prove certain points. Even those points that they were saying probably he colluded with the IBC, all these things have been put to rest. So I think it's high time Kenyans realize that their president is William Ruto.
All right. Bona Khalef, your also initial reaction to this ruling?
I think for me, what stands out is that this is a unanimous decision. They all sat down and they all agreed, that this will be a decision. So there's no dissenting voice, dissenting opinion, which means that, they've all seen the evidence from the same perspective, and they've agreed that this is something, as the Supreme Court, all 7 judges decided that, all the 9 points that were presented for, decision making, they've all agreed, that, as Orengo said it, all the points that were supposed to be argued were supposed to be, thought through. They've all decided collectively that this is the decision of the Supreme Court. And for me, because I know some of these judges, some of them have, as I said earlier, I've interacted with them, I believe that, the evidence that was adduced in court spoke for itself. And for them to come up and unanimously say that, this is the way to move forward, I will urge Kenyans to accept that decision, to move forward. The president-elect and the president of Kenya is Dr. William Samoei Ruto. And now, as Kenyans, we need to come together. What the challenge we have now is that we have a country that is somehow split in between. So the greatest challenge we have now is to bring everyone together, to maintain peace and to move forward as a country of, around 50 million Kenyans working together to achieve the aspirations and the dreams that we have as a people.
All right.
Zainab, on behalf of the, the losers, quote unquote, the Azimio fraternity, they must appreciate the fact that a president comes to lead the nation. A president does not come to lead a faction that has won. So the Constitution protects citizens from, being probably discriminated or relegated. So all these social media hula balloons we are seeing all over, people being happy, fine. People must enjoy it today, tomorrow. But the truth of the matter is that a president, once elected, leads a nation.
All right. And I think we can still have those live pictures coming to us. Dan, you can see better. Maybe just give us an idea of where exactly we're coming to you live from.
So from your top left corner, we have Karen, which is the deputy president's residence. And now We expect the president-elect to come and address the nation from there. Right next to it on the right is Karatina, which is in the county of Nyeri, which is where the deputy president-elect Rigathi Gachagua hails from. He has been the MP for Madira constituency, which sits in that county. To the bottom left, we have Sugoi, which is the hometown of William Ruto. So that is, he's a son of the soil of Sugoi. Then we have Eldoret town on the far corner next to our sign language interpreter. That's David Agondoa. We have Eldoret, which is the capital of Uasin Gishu County, which is where Sugoi is located. So this is where the president-elect comes from. So this is his home area, where we have the reaction that you're seeing on screen. We'll also be getting reactions from different various other parts of the country. And I don't know, can we listen into some of the celebrations, maybe from Sugoi?
Just before that, Dan,
Yes.
very quickly, we do know also the clerk of the Senate has called for a press briefing at around 3 p.m. And this is in light of the fact that President Uhuru Kenyatta has actually gazetted the first sitting of the newly elected members of parliament and the senators for Thursday, that's the 8th of September. That was a Gazette notice that was released today indicating that MPs will be taking their oath of office during that first sitting. And of course, after that, the lawmakers will be expected to elect speakers of their respective houses. And that will be interesting to see how that pans out as well this week. So maybe we can get just a feel, some sights and sounds from those different parts.
Sababu tuko live. Nataka tuambie hakuna nusu mkate. Hakuna nusu
So those are sides from different sports in Kenya where they are celebrating the confirmation of William Ruto as the president. And Ruto is going to be sworn in as president on the 18th of September. Sad to say that the Supreme Court did uphold the win. Anzina Baba Hazel, Nigel Toms. If servers were not opened, it means those Venezuelans hacked the system and tampered
those
with
are,
it.
again, celebrations from Sugoi in Eldoret in the county of Uasin Gishu, which is the home county of the president-elect William Samoei Ruto, which is one of the places that has burst into celebrations. And we are actually told that schools there have been closed today, just so that they can celebrate the son of their soil having been confirmed, set for swearing in next week.
Indeed, and we can see, Bridget Singana is there. Will be joining us shortly just to give us a sense of exactly the situation is there. But before that, let's head to Bondo in Kisumu County, Siaya County, I beg your
All right, so just a loss of transmission there, but we continue to bring you what's happening in Kenya there.
That petition has raised pertinent questions connected to this issue. We shall address them together with those of the sixth petitioner who has addressed and focused on the issue as specifically framed in detail. It must be restated that the case made by the sixth petitioners concerns a data-specific threshold as enunciated under Article 184 of the Constitution, that without attainment of which there can be no declaration. This data-specific threshold is what these courts declared in John Aaron Mwau and two others versus IBC and others. Petitions numbers 2 and 4 of 2017, consolidated, referred to as the ultimate yardstick for determining the winner in a presidential context. In Raila Odinga and 5 others versus IBC, petition number 5, 3, and 4 of 2013, this court asserted that rejected ballot papers do not constitute a vote cast to be included in calculating the final tally in favor of a presidential candidate. We are not persuaded by amicus curiae's brief, that is Law Society, who attempted to persuade us to consider our position on this finding. We reiterate that rejected votes cannot be taken into account when calculating whether a presidential candidate attained 50% plus 1 of the votes cast in accordance with Article 184 of the Constitution. Similarly, in the same Raila 2013 case, The court further laid down the parameters of burden and standard of proof in electoral disputes. More specifically, and this is what the court said, I quote, in the case of data-specific electoral requirements, such as those bearing the legal burden of proof, must discharge it beyond any reasonable doubt. The question that follows was whether the petitioners challenging the attainment of 50% plus one constitutional threshold and the computation by the sixth petitioner in general met the standard of proof settled by this court in Raila 2013 case. The premise of the sixth petitioner's percentage computation was a present to IBC and its chairperson, as it does in election cases. They produced video evidence correcting the percentage voter turnout to read 64.6 at the time of the briefing. This percentage, however, did not vote voters who were identified manually using the printed register of voters. In our view, the assertion by the sixth petitioner that the percentage voter turnout was firstly predicated on use to prove the correction. Secondly, the sixth petitioner based his percentage of voter turnout on the total number of registered voters, while the chairperson of IBC made reference in the press briefing to the number of registered voters who were identified through the KIMS kit progressively. The sixth petitioner also asserted that rounding off of votes cast in a presidential election as a means of assessing the threshold under Article 138(4) of the Constitution kills and bars voters, which is illegal and unconstitutional, and found that it is not mathematically sound and that the rounding off done by IBC and its chairperson was correct. Consequently, we find that the petitioners did not provide a watertight case to warrant the setting aside of the results of the presidential election on the basis of not having met the threshold provided under Article 138(4)(a) of the Constitution. On the voter turnout, therefore, we find that the formula predicated on the number of voters identified through KIMS kit progressively and used by IBC and the chairperson to generate a percentage of 64.76% was correct. Having settled the issue of voter turnout, we must ask ourselves whether in the making of the declaration, the chairperson of IBC applied the formula in Article 138(4) of the Constitution, which is total votes cast less rejected votes divide by 2 must always give 50% plus one vote. Given the numbers that were presented to us by IBC and the chairperson, this will translate to 14,213,137 divided by 2 plus 1, which makes 7.106569. The question that must inevitably follow is whether this formula votes is less than 7.176,141, which represents the number of votes received by the first respondent. We find that it is, as such, on the basis of the foregoing formula and from the numbers provided by IBC and the chairperson and the declaration by the chairperson of the president-elect on 15th August 2022, it is our finding that the declared president-elect attained 50% plus one of all the votes cast in accordance with Article 138(4) of the Constitution. Issue number 8, on whether there were irregularities and illegalities of such magnitude as to affect the final result of the presidential election. Although the petitioners have provided numerous averments pointing to possible irregularities and illegalities marked by failure of technology, arranged voter suppression, printing and utilization of Book 2 of 2, EO preparation by the IMBC and its chairperson, commission indiscretions, transposition anomalies, agent absence, and many others, we are of the view that the pointed illegalities and irregularities were not of such magnitude as to affect the final result of the presidential election. We will delve deeper into the details of this issue in our recent judgments. Last issue, what reliefs and orders can the court grant? Under Article 163(3) of the Constitution, it is provided that the Supreme Court will have A, exclusive original jurisdiction to hear. And Article 140 provides, I quote, a person may file a petition in the Supreme Court to challenge the election of the president-elect within 7 days after the date of the declaration of the results of the presidential election. 2, within 14 days after the filing of a petition under Clause 1, the Supreme Court shall hear and determine the petition, and its decision shall be final. If the Supreme Court determines the election of the president-elect to be invalid, a fresh election shall be held within 60 days after the determination. In exercising its jurisdiction pursuant to these provisions, the court sits as an election court with a mandate to determine the validity. It is clear to us that the jurisdiction of the court is quite circumscribed in terms of the orders or reliefs it can grant following the hearing and determination of the election petition under Article 140 of the Constitution. In the event the court determines that the election of the president-elect is invalid, it must make an order nullifying the election. Consequently, it has also to make an order directing IMBC to hold a fresh election within 60 days after the determination. Should the court determine that the election of the president-elect is valid, it shall issue a declaration to that effect. The court has then, as a matter of course, to make an order dismissing the petition with or without cost, as the case may be. In the strict sense, therefore, these are the only orders that the court may make under the Constitution. The court cannot assume jurisdiction that goes beyond the purview of Articles 163(3) and 140 of the Constitution. However, nothing stops the court from issuing orders or reliefs by way of recommendations. Indeed, since 2013, this court has issued many recommendations arising from the determination of 3 petitions challenging the election of the president-elect. The recommendations are meant to improve our electoral landscape and hence aid in the development of our democracy. In this regard, this court has been greatly aided by the contributions also of the amici curie, and the court places a heavy premium on those briefs that were filed and those which were admitted. The final orders made by the courts. This is a unanimous decision of the court, and we make the following order of 2022 as consolidated with the presidential election petition numbers E001, 2, 3, 4, 7, and 8 of 2022 are hereby dismissed. As a consequence, we declare the election of the first respondent as president-elect to be valid under Article 143 of the Constitution. This being a matter cutting across the public interest, we order that each party do bear their own costs. It is so ordered, And finally, the court has asked me to also acknowledge, although we'll do it in the long draft, the enormous contribution made by council in these proceedings, and also the orderly way the council, all the advocates and parties conducted themselves. They remained seated throughout the proceedings. That is the judgment of the court, a unanimous one. We shall issue a media summary to help the media summarize the case. I think that is all. Thank you very much for coming.